because he's sick and tired of this government dragging their feet on those things that are important, or the National Party just want to get rid of him. Thank you.
Michael Wood. Thank you, Mr Chair. It's a pleasure to speak on the Telecommunications, Property Access and Other Matters Amendment Bill. This is a bill as reflected on by my colleagues, notably Claire Curran, who has worked so hard on this bill and the concepts that underlie it for many years. This is a bill that the Labour Party is supporting, but there are a few issues that it's worth reflecting upon that have arisen during Select Committee stage, and I want to focus my comments in that direction, sir. The first thing I want to say is that in reading through the notes from Select Committee on this bill, the part of the bill that really that I was really excited about in terms of the work that the Select Committee has done has been around the point that was touched upon by my colleague Peter Williams-Seo, around where we have fibre that is crossing farmland and the way that we practically manage the impact on property rights. Because one of the major conceptual matters that the Select Committee has been considering when it's looked at this bill is effectively that trade-off. Because what this bill is attempting to achieve is a breakthrough in terms of ultra-fast broadband delivery, and everyone would agree that that's a good thing. But what we have practically found, since we started going down this track several years ago, is that people's natural property rights sometimes get in the way. That's the brute reality of the matter. Sometimes you need to cross someone else's land in order to get an ultra-fast broadband connection to your property. That's the core problem. And it's the duty of this House and all of its processes to consider that stuff seriously, because although we support ultra-fast broadband and its wider rollout, we also need to have a care to ensure that when we do disrupt people's property rights, we do so in an appropriate and balanced and reasonable fashion, given the benefits that we're trying to achieve. And so one of the things that drew my attention, sir, in the Select Committee's consideration is section 155 ZS and T. And these sections provide that where the owner of the existing works, in other words, the provider, is going over someone's land, particularly in a rural situation, well, how do we effectively offset for the fact that we are impinging on that landowner's property rights? And I think the solution that has been arrived at here is actually very elegant, which is that effectively we provide that landowner with a connection. And to me, sir, that is an example of some smart thinking in terms of balancing rights with things that we want to achieve at a public policy level. There were some good comments around this in the submission, so we had them being weighed up here. We had groups like Internet New Zealand, who were concerned that providing this obligation potentially makes it less likely that we'll get rollout. We had other service providers who weren't so keen. We had what looks to me like the honest farmers of various parts of New Zealand saying that we should supply to a certain length, potentially up to 500 metres, at no cost to the landowner, and where the Select Committee has settled is a distance of 200 metres free, with effectively a 50% cost offset if it goes over 200 metres. And sir, to me, that's a good balance that we've struck there and shows the Select Committee and the process working very well and balancing up the different rights of people with the public policy that we're wanting to achieve in this process, sir. Some other points that I think are just worth reflecting on in the bill, particularly in the Select Committee's considerations. Let me just grab my notes here, sir. Section 155Q, sir, which relates to the ability of rights to access being able to be withheld. And in properties where there are potentially multiple owners, this is a key issue which the bill considers. And I think of my own apartment not too far from this House, sir, where there are probably something like 80 property owners in the one apartment building. And how do you deal with access to common areas? Is there an ability for one person to unreasonably frustrate what would otherwise be reasonable access for the purposes of getting ultra-fast broadband to one or a number of the units in that apartment building? And what this section says, and it's been clarified by the Select Committee, is simply that that cannot be unreasonably withheld. So again, I think the Select Committee's done good work in this area, sir, to really go through with a fine-tooth comb and pick out the problems where we might not be getting the outcome that we want. Some other areas where I think some good work was done in that area was 155TA, sir, which limited the right of people to object when there is an ultra-fast broadband connection on the grounds that that would interrupt telecommunications during the period of installation, saying that objection is only reasonable if it's within business hours. So, Sir, I think there are some very sensible changes made by Select Committee, Sir, and we're certainly supportive of the bill. Thank you.
Gareth Hughes.
Kia ora, Mr Chair. Nā mihi nui kia koutou kia ora. Look, it's 20